A Supreme Court case is sitting there right now that could change where your carry permit actually means something in real life. Pause. And the wild part is, this challenge is not just backed by gun owners. The Department of Justice and a big group of states are backing it too. Quick question before we continue. Are you subscribed? Because what I'm about to break down could keep you from making a carry mistake in the exact place most people think is safe, legal, and routine. Hit that subscribe button now. Here's what just happened. The case is called Wolford v. Lopez, and it comes out of Hawaii. The Supreme Court already heard arguments in it, which means we are now waiting on the court's decision. And this is not some tiny local fight. This case matters because it deals with a rule that can turn normal daily life into a legal trap for licensed carry holders. Let me break this down for you in plain English. Hawaii passed a law that says if you have a concealed carry permit, you still cannot carry on private property that is open to the public unless the owner gives clear permission. That means if a store, gas station, restaurant, parking lot, or shop is private property open to the public, the default rule is no carry unless the owner says yes. Now, that may sound simple at first. Some people hear that and say, well, it's private property. What's the big deal? But here's the crazy part. Most of the places you go every day are private property open to the public. Grocery stores, pharmacies, gas stations, strip malls, hardware stores, doctor offices, convenience stores, even a lot of parking areas. So if the default rule becomes no carry unless posted yes, your permit starts shrinking fast, real fast. That is exactly why the challengers say Hawaii's law doesn't just regulate carry, they say it guts it. The DOJ made the same basic argument. The federal government told the Supreme Court that Hawaii's rule effectively wipes out public carry in the places where people actually live their lives. In other words, you may have a permit on paper, but in practice, the state can make that permit almost useless. And that's what shocked me when I dug into this. Most people think a carry case is about one of two things. Either the government says you can carry or it says you can't. But this case shows there's a third way states can do it. They can say, sure, you may carry. Then they can fence off almost every normal place you would go. So the right exists in theory, but not in your actual day. Think about that. Imagine you wake up on Saturday morning. You strap on your carry gun, you stop for gas, then you run into a coffee shop, then a grocery store, then a pharmacy, then you meet your wife for lunch. If the law says each one of those places is off limits unless the owner gave clear permission first, your normal day becomes a minefield. That is why this case matters so much, and it gets bigger. The DOJ did not stay neutral here. The Department of Justice filed a friend of the court brief. That just means they stepped in to tell the Supreme Court which side they think is right. The DOJ backed the people challenging Hawaii's law. The department argued that states cannot get around the right to public carry by using indirect tricks that make carrying impossible in real life. But wait, there's something even more important. It wasn't just the DOJ. A group of 25 states, plus the Arizona legislature, also backed the challengers and asked the Supreme Court to reverse the lower court ruling. Their message was simple. If courts allow this kind of rule to stand, more states will copy it. And your right to carry will turn into a game of mother, may I? That phrase came straight out of the state's argument, and honestly, it fits. Because that's what this becomes. Not a right. A permission slip system layered on top of a permit system. Now, this is where it gets interesting. The reason the Supreme Court took this case is not just because Hawaii passed a strict law. It's because federal courts are not all saying the same thing. And when courts disagree, that is when the Supreme Court often steps in. Here's the conflict. One federal appeals court, the Ninth Circuit, let Hawaii's permission first rule stand. But another federal appeals court, the Second Circuit, dealt with a very similar issue out of New York in the Antonia case and did not fully go the same way. So now you have a real split. One part of the country says this kind of rule may be okay. Another part sends a very different signal. That kind of split creates confusion fast. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that protect you when police ask about your gun. Subscribe so you don't miss it. Now let me explain why this matters to you, even if you never plan to visit Hawaii. First, 4 other states have used similar carry rules or versions of them. We're talking about places like New York, New Jersey, Maryland, and California. So even though this case started in Hawaii, the ruling could affect far more than one island chain in the Pacific. Second, this case is about a bigger legal question. Can a state admit that you have a right to carry, then flip the default rule so that you are banned from carrying in most places open to the public unless someone gives you express permission first? That is the heart of it. Here's what most people get wrong. They hear private property and assume this case is about forcing private owners.